This week on Rochelle's Daily Wire, video edition, we're going to talk about two cases from the Courts of Appeal that very well may end up in the U.S. Supreme Court in their term that will begin in October of this year. Let's begin with the case from the First Circuit, because that's one, I think, that has an odds-on chance of going to the Supreme Court successfully. As I said, it came from the First Circuit, and here's what happened. There was a federally recognized tribe that clearly violated the automatic stay by trying to collect a debt from an individual in Chapter 13. So, of course, he sued the tribe for damages because, the poor guy attempted suicide unsuccessfully as a result of these harassing phone calls. The bankruptcy judge dismissed the case because, in the view of the bankruptcy judge, the tribe had sovereign immunity that was not waived under Section 106 of the Bankruptcy Code. The case went directly to the First Circuit, and the First Circuit reversed, holding that there was a waiver of sovereign immunity. The circuits are split. The First Circuit disagreed with the Sixth Circuit, which had held in 2019 that there was no waiver of sovereign immunity. And then some years before that, the Ninth Circuit took a position that was followed by the First Circuit. So we have a clear split of circuits. It's an important issue, and I'm thinking the Supreme Court is likely to grant certiorari. The other case with a circuit split comes to us from the 11th Circuit, and an argument can be made that the 11th Circuit split with the Second Circuit with regard to the Coal Act, which was passed by Congress in 1992. That act says that affiliates or related persons of a coal producer are jointly liable to pay health care benefits for minors. The 11th Circuit took the position that a bankruptcy by one of those related persons relieved that entity of liability under the Coal Act. And as I said, arguably there is a split with the Second Circuit. Both of these cases, if there are to be petitions for certiorari, should be filed sometime during the summer. That means, more likely than not, that the Supreme Court will consider those certiorari petitions at the so-called long conference that is held just before the Supreme Court meets in public for the first time in the first week of October. That means, of course, that we from ABI will report on what happens. I am Bill Rochelle, ABI's Editor-at-Large. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, and good day.